Hello everyone, welcome to USA State. If you are on a visa in the United States right now, or you have a green card application pending, what I am about to tell you could change your entire plan. USCIS just made one of the biggest policy shifts in years, and most people have no idea it happened. This is not a small update. This is a rule that can decide whether you get to stay in this country while your green card is processed, or whether you have to pack your bags and leave. Stick with me for the next few minutes, because I am going to break this down in plain, simple English. Before we go further, if you find this channel helpful, do me a quick favor. Hit that like button and subscribe right now. It genuinely helps this channel keep bringing you fast, accurate immigration updates every single week. Okay, let's get into it. On May 21, 2026, USCIS quietly issued a policy memo. It is officially called Policy Memo PM 602-0199. Sounds boring, right? But this memo is anything but boring. For decades, if you were already inside the United States on a valid visa, like H-1B, or a student visa, or almost any temporary visa, you had an option. You could apply for your green card without ever leaving the country. This process is called Adjustment of Status, or AOS for short. Adjustment of status has always been treated as a routine step. If you were eligible, you filed your paperwork, you waited, and eventually you got approved. It was predictable. Families planned their entire lives around this process. That predictability just disappeared. The new memo changes the entire mindset behind adjustment of status. USCIS is now telling its own officers to treat AOS as a discretionary benefit, not a routine right. In simple words, even if you meet every single requirement on paper, an officer can still say no. USCIS actually went public and said adjustment of status will only be granted in what they called extraordinary circumstances. Read that again. Extraordinary circumstances. That is a massive shift from how things worked just a few months ago. Now here is the part that is causing real panic. This memo does not just apply to new applications. It also applies to green card cases that are already pending. So if you filed months ago and you are just waiting for your interview, this new rule can still affect you. Let's talk about who is affected the most. If you are on a dual intent visa, like H-1B or L-1, you may face less risk. These visas already allow you to have intentions of staying permanently, so officers may treat your case with a bit more flexibility. But if you are on a single intent visa, like a tourist visa or a student visa, your situation is more exposed. These visas are designed for temporary stays only, so applying for a green card while on one of these can now draw much closer scrutiny from USCIS officers. So what is USCIS pushing people toward instead? Consular processing. That means leaving the United States and applying for your green card through a U.S. embassy or consulate in your home country, instead of adjusting your status while staying here. For a lot of families, this is genuinely scary. Leaving the country while your case is pending can create real risks. There is a chance you might not be allowed back in right away, and your entire life here, your job, your kids' school, your home, gets thrown into uncertainty. Now let's connect this to something else that makes the situation even more complicated. Right now, the Department of State has paused immigrant visa processing for nationals of 75 countries. On top of that, there are travel bans affecting 39 countries. Think about what that means for a second. If USCIS is pushing you toward consular processing abroad, but your home country is on that paused list, you are basically stuck in the middle with no clear, safe path forward. This is exactly why so many immigration lawyers are worried. There is more. The public charge rule has also gotten tighter. The Department of State is now putting heavy emphasis on financial self-sufficiency when reviewing immigrant visa applications. If you have used certain government benefits, that could complicate your case. USCIS has also expanded its screening and vetting process across almost every case type. That includes deeper identity verification and broader criminal history checks. This means processing times are getting longer, and cases are being reviewed with much more caution. I know this is a lot of information, and if your head is spinning a little, that is completely normal. This is genuinely one of the most confusing periods in recent immigration history. Even lawyers are struggling to give clear answers because USCIS keeps sending mixed messages. In fact, USCIS itself has given conflicting statements. In press releases, the agency suggested that most temporary visa holders may need to leave the country and apply from abroad. But officially, they have also said the memo will be applied on a case-by-case basis. That contradiction matters a lot. It means your outcome could depend heavily on which officer reviews your file, what country you are from, and the specific details of your case. There is no longer one simple, predictable rulebook that applies equally to everyone. Now, if you already have a pending green card case and your visa status conflicts with this new memo, you might not have many options left. For example, a TN visa holder with a pending or denied I-485 case may not even be able to renew their TN work authorization. On the flip side, if your passport is from one of those countries currently facing an immigrant visa travel ban, that situation can actually work in your favor. It may weigh toward you being allowed to continue with adjustment of status here rather than going abroad. I want to pause here and ask you something. If this video is helping you understand what is happening, drop a comment below and tell me your visa type. It genuinely helps other viewers going through the same situation feel less alone, and it helps me create more videos like this. Alright, let's shift to something that directly affects almost every single green card applicant in the country right now, the August 2026 Visa Bulletin. This is published every month by the Department of State, and it decides who can actually file their paperwork. Here is how it works in simple terms. Every immigrant category has a priority date based on when your petition was filed. Each month, the Visa Bulletin publishes cutoff dates. If your priority date is earlier than the cutoff, you may be able to move forward. For August, USCIS confirmed something important. Family-sponsored applicants can use the more favorable dates for filing chart, but employment-based applicants must continue using the stricter final action dates chart. That difference matters a lot for planning your next move. Now here is some genuinely good news for family-based applicants. The F2A category, which covers spouses and unmarried children under 21 of green card holders, saw one of the biggest jumps in years. The final action date advanced by more than 18 months in a single update. For most countries, F2A moved from January 1, 2025, all the way to July 22, 2026. For Mexico specifically, it advanced from January 1, 2024, to July 22, 2025. That is a massive leap forward. It doesn't stop there. F1 advanced by about 5.5 months. F2B moved forward a full 7 months. F3 advanced roughly 3 months, and F4 progressed around 3.5 months for most countries, including China. Family categories clearly got the biggest boost this month. Unfortunately, employment-based categories did not get the same treatment. Progress there has been far more limited, and some categories remain completely unavailable for applicants from India because the annual visa limits have already been reached for this fiscal year. The State Department also issued a warning that should concern anyone in the EB1 category from India. They said high demand could make EB1 completely unavailable in the coming weeks if annual limits get maxed out. EB2 could also face slowdowns or become temporarily unavailable. Why is this happening now specifically? Because the government's fiscal year ends on September 30th. As that deadline approaches, annual visa limits get tighter and tighter, and USCIS has less room to approve new cases before the numbers reset for the next fiscal year. Now, let's talk about something else that recently made headlines, the H-1B visa program. USCIS has confirmed that the fiscal year 2027 H-1B cap has already been met. That means the door is now closed for any new cap subject H-1B filings this cycle. If you were hoping to get selected in a future lottery round for this fiscal year, that window has closed. Employers and applicants will now need to wait for the next registration period to open, which typically happens toward the beginning of the following calendar year. There is also movement happening around asylum processing. The Department of Homeland Security recently addressed a USCIS rule change specifically designed to help reduce the massive backlog sitting in the asylum system. This is part of a much broader effort to speed up case processing overall. So let's zoom out for a second and really absorb what all of this means together. Immigration policy under the current administration has moved from simply adding more scrutiny to actually restructuring entire pathways that people have relied on for decades. If you go back to 2025, that year set the tone. AI-powered background checks became a standard part of the process. Executive actions expanded, expedited removal, and biometric registration requirements. Processing resources shifted heavily toward national security priorities. Categories like refugees, diversity visa applicants, and the F3 and F4 family preference groups felt that slowdown the hardest. Enhanced vetting, deeper digital footprint reviews, and closer international data sharing became completely normal for almost everyone in the system. Now, in 2026, we have moved past just more scrutiny. We are watching entire pathways get structurally redesigned. The adjustment of status memo is the clearest example of that shift, but it is far from the only piece of this much bigger puzzle. I know if you are currently going through this process, all of this can feel overwhelming, maybe even a little frightening. But knowledge really is power here. The more clearly you understand these rules, the better decisions you can make for yourself and for your family. Here is my honest advice, and please remember, I am not your immigration attorney, so always confirm your specific situation with a licensed professional. But generally speaking, if you have a pending or upcoming adjustment of status case, get a proper case review done as soon as possible. Understand exactly which visa category you fall under, dual intent or single intent, because that single detail can significantly change how much exposure you have under this new memo. Do not just assume your case will be treated the same as it would have been a year ago. If your home country happens to be on the paused processing list or under a travel ban, factor that heavily into any decision about whether to pursue consular processing abroad instead of staying here for adjustment of status. And please do not make any big life decisions, like quitting your job, selling your home, or booking international travel, based on rumors you saw on social media. Immigration policy right now is changing fast, and accuracy matters more than ever before. This is exactly why I create these videos. My whole goal is to take confusing, dense government language and translate it into something you can actually understand and use to protect yourself and your family. That is the real reason this channel exists. If you have made it this far into the video, I genuinely appreciate you. This tells me you care about staying properly informed, and that is exactly the kind of viewer I want to keep showing up for with accurate, timely updates. Now let's talk about what might come next, because this story is clearly far from over. Immigration attorneys across the country are already preparing legal challenges against the discretionary AOS memo, arguing it removes the predictability that people have relied on for decades. Courts have already stepped in on other USCIS policies this year. Remember that Maryland court case involving USCIS and voter registration guidance at naturalization ceremonies? A judge stayed that policy and reinstated the older rule. That shows courts are actively watching USCIS closely. That means there is a real possibility that parts of this new adjustment of status memo could eventually face legal pushback too. Nothing is guaranteed, but it does show that these policies are not necessarily permanent or completely untouchable once challenged in court. For now, though, the safest approach is to treat this memo as active policy and plan accordingly. Do not wait around hoping it gets reversed. Prepare your case as strongly as possible under the current rules and stay updated in case anything changes. I want to be honest with you about something. A lot of channels and websites are spreading panic without actually explaining the details clearly. My goal here was different. I wanted to walk you through exactly what changed, who it affects, and what your realistic options actually are. If this video helped clear up some of the confusion for you, that is honestly the best compliment I could ask for. It means this channel is doing exactly what it set out to do, making immigration news actually understandable for regular people like you and me. Before you go, I need to ask you for two quick things. First, drop a comment below telling me what topic you want me to cover next. H-1B updates, student visa changes, or maybe a deeper dive into the visa bulletin categories. Your comments genuinely shape what I make next. Second, if you know someone who is currently going through the green card process or someone stressing about their visa status right now, please share this video with them directly. This information could seriously help them avoid a costly mistake or a huge surprise. Immigration policy is not going to slow down anytime soon, and honestly, neither am I. I am tracking these updates constantly so you do not have to dig through confusing government memos and legal jargon on your own. That is exactly what this channel is here for. So if you have not subscribed yet, now is the perfect time. Turn on notifications too, because the moment USCIS drops another major update, and trust me, they will, I will have a full breakdown ready for you right here on this channel. Thank you so much for watching all the way through. Stay informed, stay prepared, and I will see you in the very next video with another important update straight from the world of U.S. immigration news.